सो दिवाली की छुट्टी की तैयारी सबकी? नहीं तो लोग दिख तो रहे नहीं है. Today we will discuss 4 topics. The first topic that was in the news was that rare disease. Okay, so we will discuss rare disease and one more type of disease that was not in the news but that remains in the news for the whole of the year. That is neglected tropical disease. Look, public health is an important part of your preparation. Okay, so types of disease, their treatment, issues with respect to tackling of all the diseases. You should know all the things related to disease. Okay, that's why we have discussed that TB. Yes, we discussed TB for entirety. Yes, we have completed that polio disease. Okay, today we will discuss a rare disease and neglected tropical disease. Okay, so that was in the news on 14th October, that issues in the treatment of rare disease and what the government can do. Okay, तो rare disease क्या है पहले ये देखेंगे. इसके पहले टाइप्स ऑफ डिजीज क्या है पहले तो ये बताओ इन जनरल. बताइए diseases. How many types of diseases are there? One is congenital disease. Such diseases are there before birth. Yes or no? जो बाय बर्थ डिफेक्ट्स होते हैं, genetic diseases. Some diseases are acquired diseases, which means after birth. Yes, these diseases started after birth. Yes, moreover, acquired diseases are first communicable diseases, or we can say, आप बना सकते हो ये चार्ट बना लो. Communicable diseases, or we can say infectious diseases. Some diseases are non-communicable diseases or non-infectious diseases. Some diseases are with respect to degeneration of body tissues or organs. Body tissues or organs. With the age, okay, with the age, you will acquire such diseases like Alzheimer. Yes or no? Alzheimer's disease. Or we can say Parkinson's disease. Yes? Some diseases are with respect to allergies. Yes? Like asthma. Yes? तो अस्थमा जो डिजीज है वो कौन सी है? रिलेटेड टू एलर्जी. ओके, और क्या हो सकता है? एक और टाइप ऑफ डिजीज है. वन मोर disease is there which is deficiency disease. इसको थोड़ा सा one more disease, that is deficiency disease. Deficiency disease like vitamin A. Which one? Night blindness. Yes or no? Vitamin A, night blindness. Vitamin B, huh? berry, vitamin C, scurvy, vitamin D, rickets. Yes or no? Deficiency of protein, kwashiorkor. Deficiency of iodine, goiter. Yes. So some diseases are with respect to deficiency of vitamin, minerals, okay, protein, carbohydrate, like deficiency of iron. Which disease? Anemia. Some diseases are allergic disease like asthma. Degenerative disease. With the age, you will be witnessing degeneration in your body parts, organs, or tissues. So, Alzheimer's disease, Parkinson's disease, these are degenerative disease. Non-communicable disease, like give one or two example of non-communicable disease. Diabetes. Diabetes. Basically, these non-communicable diseases are related to your lifestyle. Yes. Uh, Hypertension, cardiovascular disease. Yes. Hypertension, cardiovascular disease. Okay. Communicable disease. What is communicable disease or infectious disease? From one person to another person. Yes. और वेक्टर बॉर्न डिजीज, तो इसमें वेक्टर बॉर्न बोल सकते हो आप. कम्युनिकेबल डिजीज इज नथिंग बट द वेक्टर बॉर्न डिजीज. एंड इन दिस वेक्टर बॉर्न डिजीज, like some of the diseases are viral disease such as HIV, chickenpox, COVID, flu. Yes, these are viral disease. Some of the diseases are bacterial disease such as TB, cholera, yes, trachoma, etc. Some of the diseases are parasitic disease, that is malaria. Some of the diseases are fungal disease. Yes, athlete's foot disease. So this is the classification of disease. Now you should prepare that disease part in this manner. तो जो भी न्यूज में रहता है उसको अच्छे से पढ़ो और उसको थोड़ा इस चार्ट के फॉर्म में प्रिपेयर करो. ओके, ठीक है. ये मैंने एक बैकग्राउंड बता दिया, अब इसको प्रिपेयर करना आपका काम है. ठीक है. We will discuss rare disease. Okay, because that was in the news. So Delhi High Court last week issued direction aimed at improving the availability of so-called orphan drugs. Okay, so there is one disease which is known as rare disease. Such diseases are also known as orphan disease. Okay, and to treat orphan diseases you need orphan drugs. ठीक है. To treat orphan diseases, you need orphan drug. So Delhi High Court last week issued direction aimed at improving the availability of so-called orphan drug, which are medications used to treat rare disease. In 2021, one policy was started, that is National Policy for Rare Disease was launched, under which financial assistance up to 50 lakh per person will be provided. Why? Because the treatment of rare diseases is expensive. Why? Because most of we can say 80% of the total rare diseases are genetical diseases और congenital, मतलब वो inherit होती है, तो उनका ट्रीटमेंट ज्यादातर का तो बना ही नहीं है. Okay, most of the rare diseases are non curable. Some of them are curable, but their treatment is expensive. Individual will be having no capacity to treat that particular disease. That is why government is providing some assistance. That is 50 lakh. Center of Excellence. COE means Center of Excellence. Includes AIMS in Delhi, PGIMR in Chandigarh, and the Institute of Postgraduate Medical Education and Research at Kolkata. कहां पे ट्रीटमेंट होगा इनका? बस 3 ही हॉस्पिटल है. Look at this situation. Okay, in India, there is only 3 center of excellence to treat rare diseases. कौन-कौन से? AIMS, PGIMER, Chandigarh, and one institute, that is Institute of Postgraduate Medical Education and Research, Kolkata. Okay, next. The following year, the Health Ministry opened a digital portal for crowdfunding and voluntary donation. What is the need to have crowdfunding? Because expensive treatment. Individual will be having no capacity to treat such diseases. And especially in India, poor people will not be having any capacity. Yes. So it is the responsibility of the government. Yes. Why? Because we are having welfare state, Article 38. Yes, Article 37, 38. Yaad aaya? Polity, welfare state. That is why government is providing. So, digital portal for crowdfunding, voluntary donation with the information about patient and their rare disease, the estimated cost of treatment and bank details of the Center of Excellence. The donor can choose the Center of Excellence and patient treatment they wish to support. Each Center of Excellence also has its own rare disease fund, which is used to approve from its governing authority. In 2024 August, the government told Parliament that financial assistance up to 24 crore had been released to Centers of Excellence for treating rare disease patient until August in the current financial year. Before that, कुछ डेटा दिया हुआ है. ठीक है? Some facts about rare disease. 7,000, according to the National Institute of Health, there are 7,000 rare diseases. Okay, 7,000 rare diseases. Only about 5% of the rare disease can be treated. So out of 7,000, only 5% can be treated. Most of the rare diseases can be diagnosed with the genetic testing. Why? Because most of them are congenital. They are inherited disease. Okay, the rare disease are not easily detected, which is why there is a delayed diagnosis. And in India, it affects nearly 30 million people, which means 3 crore people in India. Okay, that is why we are having dedicated policy, which is national policy for rare disease. One, second, Center of Excellence to treat that disease, and third, digital portal for crowdfunding and voluntary donation. Is it okay? Next, rare disease hota kya hai? WHO gave the definition that debilitating lifelong condition that affects one or fewer people out of 1,000 people. Okay, 1,000 लोगों में से सिर्फ एक व्यक्ति को होने वाली डिजीज को रेयर डिजीज बोला है WHO ने. Rare disease, also known as orphan disease, are conditions that affect a small percentage of population. In India, the impact of rare disease is significant due to the country's large and diverse population. Prevalence and types of rare disease. So India is a home to over 450 identified disease. Overall तो कितनी है? 7,000. But out of 7,000 in India, we identified 450 diseases. Some of the most prevalent include spinal muscular atrophy, Gaucher's disease, है ना? बहुत सारी हैं, ये सारी यहाँ पे लिखी हैं. Thalassemia, sickle cell anemia. Sickle cell we have discussed. What was sickle cell, है ना? तो ऐसी जो भी न्यूज में रहेगी हम थोड़ा बहुत तो उसको डिस्कस कर लेंगे. ठीक है? Sickle cell anemia, lysosomal storage disorder, congenital insensitivity to pain, acquired aplastic anemia, muscular dystrophy, multiple sclerosis, sweet syndrome, pediatric cardiomyopathy, etc. Okay, 50% babies are born with the rare disease, die within a year. ये एक issue है. दूसरा, 80% of the disease occur at birth and are genetic in nature. Okay, congenital in nature. Estimate 9 to 10 crore number of people in India who suffer from the rare disease, which is 25% of the global patient. तो एक बार ये पढ़ लेना, समझ में आया? What is a rare disease? Basically, this is the classification of all the diseases: congenital disease and acquired disease. So most of the rare diseases are congenital diseases. They are not acquired diseases like communicable diseases, non-communicable diseases. Most of them are congenital. Okay with this? Okay. Then around 55 medical conditions, that is rare disease, including Gaucher's disease, lysosomal storage disorder, and certain forms of muscular dystrophy, are classified as rare disease. Basically, overall, how many diseases are rare disease? 7,000. For 450 rare disease identified in India. And how many classified? कितनी दिया हुआ है? 55. Okay. Overall 55 classified in India. Present कितनी है? 450. उनमें से 50 क्लासिफाई करके उनको ट्रीट कर रहे हैं. ठीक है? National Registry for Rare and Other Inherited Disorder, started by ICMR, has record of 14,472 rare disease patients in the country. Therapies are available for less than 5% of the rare disease, leading to less than 1 out of 10 patients receiving disease-specific care. Existing treatment are often very expensive, while the center provide the financial assistance to various center of excellence. कितने हैं इंडिया में? सिर्फ 3. Okay, so these diseases can be treated only at 3 places, है ना? एम्स, चंडीगढ़ and Calcutta. Okay, next. Categories of rare diseases. So overall 3 categories है. 1, ये चल नहीं पाएगा ऐसी? बोल क्या हो? Yes, yes. बोल दिया? Okay. So in India, all the rare diseases are classified in 3 parts or 3 groups. One is group 1, included diseases that can be treated only one time curative procedure. Other diseases require long-term, lifelong treatment, which are relatively less costly. And the last one is lifelong treatment, which is costly. Okay, 3 types of rare disease. Although nobody is going to ask you this question in mains, but we have to ready for it. Yes. So for prelims, is it clear what is a rare disease? What is a rare disease? WHO gave definition that 1 out of 1,000 people. Okay, a rare disease. How many rare diseases are there? Around 7,000 globally. Okay, out of which 450 identified in India and 55 classified. 55 classified. Yes. What are the policies that government of India initiated to treat rare diseases? National policy, rare diseases. 1, that donation and crowdfunding portal. 2nd, 3rd, center of excellence. And 4th thing, that classification by ICMR. Yes. So 4 initiatives are there. Give some examples. Give some examples of rare diseases like sickle cell anemia, thalassemia, muscular entropy, etc. Okay. And are these diseases acquired diseases or congenital diseases? Most of them are congenital diseases, and only 5% are curable or treatable. Is it okay? Yes. Challenges in diagnosis and treatment. So complex diagnosis है. Why? Because most of them are genetical. So those genetical diseases cannot be diagnosed easily. Diagnosis of rare diseases is challenged due to the lack of specialized medical professionals and testing facilities. Limited treatment option. We have already discussed that only 5% of the rare diseases are treatable. Awareness and education. There is in general lack of awareness among healthcare providers and public. जब healthcare providers को ही पता नहीं है, yes, so we cannot expect that normal people like us will be having any knowledge regarding rare diseases. Then impact on the patient and family. Financial burden. Why financial burden? Because government itself is providing 50 lakh per person. तो आप समझ सकते हैं कि कितना फाइनेंशियल बर्डन होगा. Then emotional stress, quality of life will be impacted of that particular person. Government initiative, we have already discussed that. Okay. Orphan drugs. Now, orphan drugs are the drugs which is used to treat rare diseases, because rare diseases are also known as orphan diseases. Now, orphan drugs are medication specifically developed to treat the rare diseases which are condition affecting a small percentage of the population. These diseases are often referred as orphan because they are neglected in terms of research development due to their low prevalence. Yes, research and development, those biotech giants are not spending enough money on research and development of such drugs. Why? Not profitable. Simple funda hai. Yes, market driven economy, and in the market driven economy they will invest money only on those places where they can get good return. Yes, so in this particular research they will not be getting enough return. That is why no research and development in India. An orphan drug is defined as a medication intended to treat a condition affecting fewer than 5 lakh people in the country. Okay, क्या है देख लो. Price in Indian rupee for monthly treatment कितना? 3,42,000 monthly treatment, and overall treatment cost is 41 lakh. That is why government is providing 50 lakh per person. Okay, अब इनका नाम देख लो एक दो का. क्या है? Venclexta, Cyprine. Okay, so these are orphan drugs. Okay, next. Challenges: high cost, limited market, एक्सेस इशू, रेगुलेटरी सपोर्ट. ठीक है, ये सारा देख सकते हो इजीली. ये कुछ डिजीजेस हैं, कुछ नाम है उनके, लाइक एलाप्रेस फॉर हंटर सिंड्रोम, एल्डुराइजाइम फॉर हर्लर सिंड्रोम, विमिजिम फॉर मोरिको ए सिंड्रोम. These are the orphan drugs and subsequent corresponding to that rare diseases. Now, we have completed that topic, rare diseases and orphan drugs. Okay, similar to that, one more type of disease is there which is known as neglected tropical disease. By name it is clear. Tropical means what? In the tropical region. And in most of the tropical region, which type of countries are lying? Developing countries or underdeveloping countries? Yes or no? Like African countries, Asian countries, and South American countries. Okay, so neglected. Why neglected? Because such diseases are not prevalent in developed world. These diseases are not prevalent in developed world. That is why they neglected these diseases in terms of research and development for the medication. That is why these diseases are known as neglected tropical disease. नाम में क्लियर हो गया. ट्रॉपिकल डिजीजेस which means their concentration, they are mainly concentrated in the tropical areas. Tropical areas are present in which countries or which type of countries? African, Asian, basically global south. Yes, global south. And who is having capacity to develop medication or to do research and development? Developed countries. So they are neglecting because they are not affected by these diseases. Now, according to the common sense, neglected tropical diseases will be communicable diseases or non-communicable diseases according to you? सोच के बताओ थोड़ा सा. Non-communicable or communicable? Non-communicable. Why non-communicable? नहीं यार. Communicable or non-communicable? Most of these diseases are communicable diseases. Okay, not non-communicable, communicable diseases. Because in developed world, non-communicable diseases is having greater burden on public health care. Non-communicable diseases means hypertension, diabetic. Okay, so developed world is equally impacted by communicable diseases. But developed world is not having that type of climate where vector-borne diseases like mosquito-borne diseases are very much prevalent because their climatic condition is not suitable for the breeding of mosquitoes. Yes or no? है ना? That is why most of the neglected tropical diseases are communicable diseases, vector-borne diseases. Why? Because of our climatic condition. है ना? देख लेते हैं. नेग्लेक्टेड ट्रॉपिकल डिजीजेस आर ए ग्रुप ऑफ, यही लिखा हुआ है सामने, यही देख के बता देते. Communicable diseases that predominantly affected the impoverished community in tropical and subtropical region. These diseases are often overlooked in the global health priorities. Why? Clear way? Because these are not prevalent in the developed world. So they are often overlooked in the global health priority despite their significant impact on the health, social, economic development. Here are some of the key points of NTDs. NTDs include a variety of disease caused by different pathogens such as viruses, bacteria, parasite, fungi, and toxins. Common example such as चिकनगुनिया, ये सब हम इंडिया में देखते हैं या नहीं? चिकनगुनिया, डेंगी, काला अजहर, एलिफेंटिसिस, दैट इज लिम्फेटिक फिलियरेसिस. ओके, तो ये सारी डिजीजेस के नाम है. रेबीज, डेंगी, चिकनगुनिया एटसेट्रा. स्नेक बाइट. एंटिटीज अफेक्ट ओवर 1 billion people worldwide. Still they are neglected. ओवरऑल पॉपुलेशन कितनी है दुनिया की? 8 billion. Yes. So out of 8 billion, they are impacting 1 billion population worldwide. Still they are neglected. Okay. Around 1.66 billion people requiring intervention. These diseases are associated with the severe health, social, and economic consequences, often perpetuating the cycle of poverty. The epidemiology of NTDs is often complex, involving vector-borne transmission, animal reservoir, and intricate life cycle. Public health control is challenging due to the environmental factors, limited access to the health care in the affected region. Which one is the affected region? देख लो. Tropical. Most of the countries are South American, African, and Asian countries. Okay. Basically underdeveloped or developing countries. Next, India is a home of 12 neglected tropical disease, making it a significant area of concern for public health effort. NTDs are a significant public health concern in India, affecting millions of people, particularly उसमें से भी कौन से होंगे? Impoverished region. Here are some of the points. Common, okay? क्या नाम है इसका? Aceriasis, the type of intestinal worm infection. Hookworm infection, trichu, Rhiasis, dengue fever, lymphatic filariasis, trachoma, and melioidosis. ये सारी डिजीजेस हैं जो इंडिया में है. बेसिकली 12 डिजीजेस हैं. इनका नाम थोड़ा सा पता होना चाहिए आपको. ओके, यू शुड रिमेंबर द नेम बिकॉज इन प्रीलिम्स they will be giving you the names out of which you have to that eliminate one or two name that this particular disease is not neglected tropical disease. Okay, so revise it, 2-3 बार पढ़ोगे तो हो जाएगा. ठीक है. Next, leprosy, echinococosis, visceral leishmaniasis, rabies. Entities causes significant morbidity and mortality, leading to the chronic health issue, disability, and social stigma. They are often prevalent in the area with poor sanitation, limited access to clean water, and inadequate healthcare infrastructure. Basically, poor area. Government initiative. Indian government has launched various programs to combat entities, including mass drug administration campaign, improving diagnostic and vector control measure. Efforts are also being made to integrate entity control with the other health related initiative. Collaboration with international organizations like WHO and local NGOs is crucial for the effectively management and eliminating of entities. Okay, so is it clear? Rare disease, first topic. Second topic is entities. Clear हो गया पूरा disease वाला? Okay, what is entities? They are mostly prevalent in tropical region but often neglected. Why neglected? Because they are present in the developing and underdeveloped world. That is why the developed world is overlooking these diseases despite being being having large impact of these diseases. और इंडिया में कितनी है ओवरऑल? 12 entities are present in India, including dengue, जो कि अभी सीजन चल रहा है डेंगी वाला. Okay, done with this. Now, second topic, that is how bone ossification test work and its application in the law. That thing was in the news last week. What happened in Bombay? That Baba Siddiqui, okay, one of the politician was killed by four gunmen. Yes, out of which one was minor. Okay, one was having age of 17 years. And as we know that in India, what is the definition of a child? Under 18. Okay, so that 17-year-old kid will be considered as a child, and that particular kid will not be tried with the normal Bharatiya Nyaya Sanhita. Yes or no? He will be treated under Juvenile Justice Act. Okay, so in the last lecture we have discussed that NCPCR. Yes, so today we will discuss that Juvenile Justice Act as well. Okay, so one thing that MLA Baba Siddiqui claimed before a court in Mumbai on Sunday that he was 17-year-old and should thus tried under the Juvenile Justice Act. Okay, first thing. Second, Mumbai Police Crime Branch, which sought the custody of accused, said that Aadhaar card found on that particular individual is showing that he is 19-year-old. So there is a dispute regarding his age. Okay, and in India, manipulation with respect to date of birth can be easily done. Yes or no? देखा है आपने? One of the candidate of UPSC is playing with the UPSC. Yes, and she is still playing with the UPSC. Okay, so Aadhaar card is saying that he is 19-year-old, but he is claiming that he is 17-year-old. And he should be tried under Juvenile Justice Act. Why Juvenile Justice Act? Because under this particular act, punishment will not be that much severe. Okay, and he will not be sent into that normal prison where most of the criminal will be sent. He will be sent in the that child prison बोल सकते हैं उसको आप, child welfare homes. Okay, to determine whether the accused was a minor, the magistrate ordered bone ossification test, which was carried out in the state-run JJ hospital after the report established that the accused Dharmaraj Kashyap was not a minor. The court remanded him in the police custody until the October 21. Now, what is ossification? This is the process of ossification. Okay, ossification is the term used to describe a process of bone formation by deposition of calcium in the fetal hyaline cartilage. All bones develop from the, क्या नाम है इसका, पढ़ लो, ठीक है. So basically this particular ossification process will start when fetus starts developing in the womb of the mother. That calcium deposition starts. So basically in the bone ossification test, they will measure that calcium deposit in your bone, and on the basis of that they will determine your age. That is the bone ossification test, nothing else. So what is the bone ossification? Why? It is the natural process of bone formation. It starts from the early developmental stage of the fetus and continues until the adolescence. Differs slightly from individual to individual. Based on the stage of development of the bones, experts can determine the approximate age of the person. Bone ossification test, X-ray of the few bones, such as those of hands, like wrist bone. Okay, iska hoga bone ossification test. Wrist are conducted to determine the skeletal and biological development. The images may be compared with the X-ray of the standard development, which can assist in determining the age. The analysis could also be based on the scoring system that looks individual bone on the hands and wrist and their growth and compare them with the standard of maturation of bone among the certain population. So what is bone ossification test? Ossification is the normal process. Okay, it is the natural process in which in certain cartilage, क्या नाम था उसका cartilage का? क्या है? Mesenchymal cartilage, where calcium will be deposited. And in bone ossification test, that calcium deposition will be measured with the standard measurement, and on the basis of that your age will be determined. In what cases? Where there is a doubt with respect to your age. Is it okay? This is bone ossification test. This can be asked in the prelims, not in the mains. Under section 94 of Juvenile Justice Act, where it is obvious, सुन लो इसको पहले, where it is obvious based on the appearance that said person is a child, the board can proceed without confirmation of the age. But if there is a reasonable ground of for doubt, the board undertake the process of age determination. So it is mentioned in the Juvenile Justice Act. Okay, that if there is a doubt with respect to the age, आप बात क्यों कर रहे हो दोनों? If there is a doubt with respect to the age of an accused, then board can order that age determination test, which is known as bone ossification test, and which is mentioned in Juvenile Justice Act section 94. Evidence has to be obtained from the date of the birth certificate from the school, the matriculation or equivalent certificate from the concerned examination board. If these are not available, a birth certificate issued by a municipal corporation or authority or panchayat may be concerned. तो यहां से भी नहीं मिलेगा, then फिर तो कुछ करना पड़ेगा. Now this person is claiming that I am 17-year-old. Aadhaar card is saying 19-year-old. Doubt हो गया. Okay, and that can be ordered. Only in the absence of these, age shall be determined by the ossification test or any other latest medical age determination test conducted on the orders of the committee or the board. In an order passed by March this year, Supreme Court also said that tests such as ossification test is the last in order of priority to determine the age. So it should be the last priority. It is the order of the Supreme Court. Okay. Next, the court have held that the test cannot override the documentary evidence on the age of such an accused person. Okay. So it depends upon the court whether they are accepting the date which is written in the Aadhaar card or not. Getting my point? Okay. The next thing is, in some cases, court have rejected the pleas by accused seeking a test when documentary evidence is already present. The point is, the documentary evidence that is present before the court is not the matriculation certificate or any such birth certificate. It is Aadhaar card, which is not written in the juvenile justice, okay, which is not mentioned as a documentary evidence in the Juvenile Justice Act. Otherwise, court may not have been ordered that bone ossification test. वो उसी को मान लेता, क्योंकि यही दिया हुआ है ना यहाँ पे, that that ossification test cannot override the documentary evidence. So it should be the last resort, ossification test. Then, how reliable the bone ossification test? Variability in observing the maturation of bone could impact the accuracy of the test. Also, the slight difference in the development among the individual leaves some scope for error. Ossification test give a range, say 17 to 90. और issue भी तो यहीं पे है. It will give a range, and doubt with respect to this range. He is claiming that I am 17-year-old. Documentary evidence, that is Aadhaar card, is suggesting that he is 19-year-old. And there is a chances of error in ossification test as well. So Delhi High Court said this year that in POCSO Act, cases where the age of the victim is determined through an ossification test, the upper age in the test reference range should be considered and the margin of error of 2 years required to be applied. So basically, court will consider the upper range. And what is the upper range? Again, 19-year-old. Are you getting my point? Okay, so ultimately he will be prosecuted. ऐसा कुछ होता है तो देखते हैं. Now, what is age determination significant in the criminal justice system? As we have discussed the POCSO Act, and right now we are discussing Juvenile Justice Act. Both the acts are giving definition with respect to child, that any person is a child if he is not completed the 18-year age. That is why age determination is crucial in Indian judicial system, because before 18-year age, if you are an accused, then you will be tried under different set of laws. Yes, and if you are above 18 year of age, then you will be tried under different set of laws. That is why age determination is crucial. In India, a person is below 18-year age is considered as the minor. The criminal law differentiates between a child as and an adult when it comes to the procedure, correction, rehabilitation, and punishment. What is the procedure? A normal accused who is above 18 years of age will be tried under Bharatiya Nyaya Sanhita. Yes, सिविल प्रोसीजर कोड, क्रिमिनल प्रोसीजर कोड, उसके लिए एक अलग सेट ऑफ लॉज है, तो उसका प्रोसीजर अलग है पूरा. देन इफ यू आर below 18 years age, then you will be tried under Juvenile Justice Act. Punishment will be different. In normal case, you will be sent in the normal prison. Under Juvenile Justice Act, you will be sent in the juvenile prison. Anyone below the 18 years is governed by Juvenile Justice Act 2015. A child who is found to be in the conflict with law. Child is found in the conflict with the law. Matlab, a child who, who is a criminal or who is accused that he committed certain crime. Law cannot be sent to a prison meant for adult and instead sent to an observation home. Okay? Instead of a court, the child is brought before the Juvenile Justice Board, comprising a magistrate and 2 social workers with the experience in the working with the children. After an inquiry, the board may direct the child to be let off with an admonition, community service, or maximum 3 years in a special homes. Special homes का मतलब वही है, juvenile prison, basically. Okay. Next, the following amendment in Juvenile Justice Act 2021 in cases where a child is above the age of 16 years has been apprehended for a heinous crime. Okay. So basically, Juvenile Justice Act classified children into 2 parts after this particular amendment. Okay. One, that is from 0 to 16 years of age, and other children that is 16 to 18 years of age. Okay, so those who have 0 to 16 years, they will be examined by Juvenile Justice Board and sent to the juvenile prison. They will be assessed by Juvenile Justice Board, may be sent to the normal prison or juvenile prison. It is the process. So this, and why this particular amendment was made? Is there any reason? What is the background of this particular amendment? Yes, Nirbhaya case. One of the accused in Nirbhaya case, that Delhi gang rape case, that one of the accused was below 18 years of age. And after that, government constituted one committee, that is Justice Verma Committee. And that committee recommended this particular amendment. Okay, that is the background. To accept those recommendations, government amended Juvenile Justice Act in 2021. Is it okay? So in the cases where a child above the age of 16 years has been apprehended for the heinous crime for which the minimum punishment is 7 years imprisonment, the Juvenile Justice Board must conduct a preliminary assessment with regard to his mental and physical capacity to commit such offense, ability to understand the consequences of the offense, and the circumstances in which he allegedly committed the offense before deciding whether the child should be tried as an adult or not. Okay with this? Okay, so after this amendment, overall children are classified into two parts. One, 0 to 16. Another category is 16 to 18. Those who are involved in the some heinous crime. Okay with this? Next, जुवेनाइल जस्टिस एक्ट, इसके बारे में भी देख लेते हैं थोड़ा. इट इज द कॉम्प्रिहेंसिव लॉ in India that address the need of a children in conflict with the law and those in the need of care and protection. Here are some of the key aspects. Basically, Juvenile Justice Act is all about four things. First thing is Juvenile Justice Board. Second thing is Child Welfare Committee. Third thing is Kara. And fourth thing are other provisions. Juvenile Justice Board. It is the constitutional body. Sorry, statutory body, not constitutional body. Juvenile Justice Board is the statutory body. Child Welfare Committee is the statutory body. And Kara is the statutory body. This body will do that preliminary inquiry, that whether a person should be sent into that prison or juvenile home or या सिंपल डांट के छोड़ देना चाहिए. Child Welfare Committee will be looking after those children who are in the conflict with law and those who are present in the juvenile home. Okay, and that Kara will be looking into the matter of adoption. Okay, earlier that Kara was not having statutory status, but Juvenile Justice Act 2021 और 15 है ना, पहले तो ये 2015 है, बाद में इसमें एक अमेंडमेंट हुआ that is in 2021. So basically it gave statutory status to Juvenile Justice Board, Child Welfare Committee and Kara. ठीक है? What are other provisions? Purpose. The act aims to provide a child-friendly approach in the adjudication and disposition of matter involving the children. It focuses on the rehabilitation and reintegration of the children through various child care institute. Juvenile Justice Board. First thing, the Juvenile Justice Board is responsible for handling the cases like the normal court for normal people. Juvenile Justice Board is nothing but the court for the juveniles, handling the cases involving children in the conflict with the law. It ensures that the children are treated differently from the adults and provide for their rehabilitation. So this is the first institute statutory status. The second, Child Welfare Committee. Child Welfare Committee deals with the children in need of care protection. It has the authority to make decision regarding the care, protection, treatment, development, rehabilitation of such children. ठीक है? Two institute. Other provisions जो क्या है? Age of juvenility. Act defines a juvenile as a person who is below 18 years of age. Heinous offenses for children aged between 18 to 16 to 18 years who committed heinous offense. The act allows preliminary assessment by juvenile justice board to decide if they should be tried as an adult or not. Adoption. The act streamlined the adoption process and established Central Adoption Resource Authority, that is CARA. So basically, Juvenile Justice Act is all about three bodies. One is Juvenile Justice Board, that is nothing but the court for all the juveniles. Yes. Second one is Child Welfare Committee. What is Child Welfare Committee? जैसे ही बोर्ड का काम खत्म हुआ, Child Welfare Committee will come into picture. Yes or no? Child Welfare Committee will look after all the things: protection of that child, care of that child, rehabilitation, reintegration of that child. And one more body is there, that is CARA, Central Adoption Resource Authority. So these three statutory authorities established by Juvenile Justice Act. Okay. Rehabilitation and social reintegration. The act emphasizes the rehabilitation and reintegration of children through various means such as foster care, sponsorship, aftercare, etc. Penalties. The act include provision for penalties of offense against the children such as cruelty, employment of children for begging, exploitation. Juvenile Justice Act 2015 is a significant step towards ensuring the rights and welfare of children in India, providing a framework for protection, care, and the rehabilitation. Is it okay? So, with respect to your social justice paper, we have completed or almost completed that child topic. है ना? Social justice paper, social justice section of GS paper 2. Yes, we have completed that POXO Act. We have completed Juvenile Justice Act. दिस इज ऑल फॉर दैट पर्टिकुलर टॉपिक. इससे बाहर उसमें टॉपिक में क्वेश्चन नहीं जाएगा. ठीक है. नेक्स्ट, व्हाट इज जुवेनाइल? दिस टॉपिक इज रिलेटेड टू योर सोसाइटी, क्योंकि अब इतना पढ़ी लिया है तो पहले ये भी देख लें. ठीक है. व्हाट इज जुवेनाइल डिलिक्वेंसीज? बिफोर दैट राइट डाउन सम पॉइंट्स विद सम इश्यूज विद रिस्पेक्ट टू जुवेनाइल जस्टिस एक्ट. फिर इसको देखते हैं. Juvenile Justice Act. Issues. First, NCPCR pointed out. What was NCPCR? National Commission for Protection of Child Rights. NCPCR pointed out that no child care institution. 3 years ago, there was one news from Bihar, Muzaffarpur, that one MLA or MP of that particular area was involved in the abuse of those girl child. Yes, that was nothing but the Child Care Institute. And that MLA was running that particular institute. तो वहां पर overall 58 girls child reported that they were faced abuse from that guardian who was running that child care institute. बड़ा फेमस केस था, बहुत यूएन क्राई हुआ था उस बात पे. बिहार का केस है, मुजफ्फरपुर केस. कर देना उसको सर्च, आपको पता चल जाएगा. So that is pointed out by NCPCR. NCPCR pointed out that no child care institution is fully complied with the provision of Juvenile Justice Act. Is fully complied with the provisions of Juvenile Justice Act. Provisions of Juvenile Justice Act. First. Second issue with this, there is no specific criteria. There is no specific criteria to check the background of the member, to check the background of the members, check the background of the members of Child Welfare Committee. Background of the members of Child Welfare Committee. Third, Justice, Juvenile Justice Committee. Juvenile Justice Committee of Supreme Court highlighted that 800 to 1000 adoption cases, 8,000 to 100 adoption cases are pending in various courts. Adoption cases are pending in various courts. Next, no clear definition of serious offense and minimum sentence. Serious offense and minimum sentence. Next, Ministry of Child Development observed increase in child abuse and trafficking. Increase in child abuse and trafficking during COVID-19 lockdown. During COVID-19 lockdown. During COVID-19 lockdown. During COVID-19 lockdown. Okay. So these points complete our Juvenile Justice Act. GS paper 2. Now GS paper 1. What is juvenile delinquencies? नाम सुना है कभी इसका? No? There was one incident in Lucknow. Incident from Lucknow. That one child was playing PUBG for more than 3 hours. He was interrupted by his mother by saying that बस बंद कर यार, बहुत हो गया. And he got irritated because of that and he killed his mother. ये 2 साल पहले की बात है. He killed his mother. This is juvenile delinquency. Okay? Definition है, सोसाइटी का पार्ट है ये आपका. Juvenile delinquency refers to the participation of minor, typically individual under 18 years of age, in illegal and antisocial activities. Here are some key points understand about the juvenile delinquency. Juvenile delinquency involve unlawful behavior committed by minors that would be considered as a crime if committed by an adult. So that is crime for adult, but that is delinquency for a juvenile or for a children, like pickpocketing. Yes, by children. That is juvenile delinquency. Antisocial behavior, basically. It also includes persistent behavior of disobedience antisocial action that lead to legal intervention. Types of offender. एक तो होते हैं repeated offender. These juvenile engage in criminal activity consistently over the time, often continuing into adulthood. This is a big issue. If that particular crime committed by a children, if left untreated or unaddressed, then he will definitely commit some big crime in the future. Yes or no? That is why there should be some treatment or some redressal mechanism for that. Age specific offender. These juvenile exhibit delinquent behavior during adolescent, but typically ceases such activities as they transition into adult. कुछ टाइम के लिए वो ऐसी एक्टिविटी कर देते हैं, but when they will get mature, they will left all these activity. Common causes. What are the common causes why children are involving into anti-social activity in India? Is there any specific reason? Basically, we are discussing this particular topic with respect to our society paper, so give answer according to that. Online students, why juvenile delinquency increases in India? Social structure. कैसे? यस, पुअर पेरेंटिंग बोल सकते हैं. यस, और नेग्लिजेंट पेरेंटिंग, that parents are not giving enough attention to that child. Yes, this is a one thing. Second thing is poor socio-economic condition, especially the poor children who are living in slum areas. Okay, there are higher chances that they will get involved in such antisocial activities. Other, like, explain it. Mental health issue. Explain how mental health is impacting their social behavior. Drugs, yes. Taking drugs is another type of delinquency. Social media, yes. Exposure to social media, this is another issue. Juvenile delinquency, very good. More. आपका वो मेंटल हेल्थ वाला क्या था इशू, उसको बताओ. प्रेजेंस ऑफ सोशल इविल्स इन सोसाइटी, लाइक व्हाट राहुल? बच्चों को क्या समझ में आएगा डिस्क्रिमिनेशन, इतना नहीं आएगा. Changing social structure, like disintegration of joint family. Earlier, that joint family was taking care of that child. In the socialization, your grandparents played an important role. But right now, both the parents are working. That particular child is left at the home. Okay, and someone else is taking care of that particular children. Earlier, that socialization was done by your grandparent. Yes, and they will constantly checking your activities. Yes, so one of the major factor is change in the social structure, that we are transitioning from joint family structure to nuclear family structure. So that social support or the agent of socialization is missing. That is your grandparent or extended joint family that was taking care of your socialization. Okay, there is one more sociological term, that is adult personality stabilization. Like various stories, like दादी नानी की जो stories हैं, so they are moral stories. Yes, तो उससे भी हम बहुत कुछ सीखते थे. That is also missing. Now everything is available on internet. So rather than listening to those stories and learning from the knowledge or wisdom from our grandparents or our elderlies, we are more and more relying on the internet. And on internet, yes, definitely there is more knowledge and more wisdom on the internet, but there are many such things, many other things are also present on internet, and there are chances that a child will consume those things as well. Yes, and he or she will be involved in antisocial activity. So one of the major factor is that change in this societal structure from joint family system to nuclear family system. Second thing is change in value system. Earlier, the value system was collectivism. Yes, that collective identity होती थी, हमारी family, ये वो है ना, वो सब collectivism. Now that collectivism is turning into individualism. My liberty, my freedom, my life, my choice, like this. Okay, so change in the societal structure, change in the value system. और बाकी तो सारा है ही सही, लाइक इंटरनेट और दुनिया भर की बातें, वो सारा आ जाएगा. ठीक है, ये हो गया. एंड मोर ओवर, such activities are more prevalent in urban area rather than in rural area. Why? What is the reason? गांव में भी आजकल वाईफाई चलने लगा है. लैक ऑफ एजुकेशन अर्बन एरिया में कैसे होगा? I am saying that child delinquency or juvenile delinquencies are more common in urban areas rather than in a rural area. Why? Yes, in a rural area, that social structure is still intact. First. Second, in a rural area, the sense of anonymity is not there. But in urban area, nobody knows you. Whatever you are doing, just do. Yes or no? Nobody is going to stop you. But in a rural area, everyone knows you. And those people will act as an agent of social control. आप सोसाइटी में ये पढ़ेंगे, है ना, एजेंट ऑफ सोशल कंट्रोल. बट इन अर्बन एरिया, एनोनिमिटी इज द वैल्यू. यस, सो नोबडी इज एक्टिंग एज एन एजेंट ऑफ सोशल कंट्रोल. अब जब सोशल कंट्रोल नहीं है तो आपके मम्मी पापा ने देखा नहीं, तो फिर तो जो मन में आए वो करो. यस, ये तीन चीजें सबसे इंपॉर्टेंट है, बाकी तो ये लिखा हुआ है. पीयर इन्फ्लुएंस है, एसोसिएटेड विद द delinquent peer can encourage similar behavior. Socioeconomic factor, poverty, lack of psychological factor, mental health issue, substance abuse, personality disorder, etc. ठीक है, लेकिन दो तीन पॉइंट और लिखना है इसमें. पहला, चेंज इन द सोशल स्ट्रक्चर. सोशल स्ट्रक्चर. वन, फ्रॉम जॉइंट फैमिली टू न्यूक्लियर फैमिली. इंपॉर्टेंट है. सेकेंड, change in the value system, that is from collectivism to individualism. And third, from rural area to urbanization. And what is present in urbanization? Anonymity. These are the three important factors. लिख लीजिए जल्दी से. यस, कल्चरल इन्फ्लुएंस बोल सकते हैं. ओके, प्रिवेंशन, एजुकेशनल प्रोग्राम, काउंसलिंग, थेरेपी, कम्युनिटी प्रोग्राम, सब कॉमन है, देख लेना इसको. एक अच्छा कोट है ये. There is but one way to eliminate juvenile delinquency, that is by providing each child in America, each child in India, लिख देंगे यहाँ पे बस, each child in India a competent parents. because they are the primary agent of socialization. Okay, so good parenting is the solution. On Samsung workers right to unionize, that was all also in the news, that protest is going on in Chennai. Okay, that Samsung plant is there and all those workers are protesting. So that protest, all those workers are on strike and they are exercising their right to strike. Now हमारे वो पूरा काम का नहीं है. There is two things: right to protest, and another thing is right to strike. What is the difference between two? One is right to protest, one is right to strike. Are they same? No. How they are different? लग तो सेम में रहा है. Yes. What is right to protest? What is right to strike? Is there any difference? पॉलिटी क्लास वाले तो बता दो कम से कम. नाक मत कटवाओ यार. हाँ, अरे नहीं यार, ऐसा थोड़ी होता है. स्ट्राइक में वायलेंस कर सकते हैं क्या? नहीं, ऐसा नहीं होता है. नो. यस ऋषभ बताओ. And in protest you can do this. नहीं यार, in right to protest, that is the reasonable restriction which is mentioned in article number 19, that public order, morality, yes, these are the reasonable restriction. You cannot disturb public order while you are protesting. That is why most of the protesters sit on that particular Ram Leela Maidan after taking permission from the government that we will not impact public order. Yes or no? The reasonable restriction on the ground of public order, government can deny that right to protest. Okay, ऐसा नहीं हो सकता. और कुछ, any difference? So look, article number 19 is there. Article number 19 is your fundamental right. One of the article is saying that the right to protest or organize protest is your fundamental right. Okay, right to protest is your fundamental right. It is one of the freedom which is mentioned in the constitution. Like student protest was going on in ORN. Yes, हुआ था. That is the protest. You got the idea? This is your fundamental right. If some of the demands are not met by the government, then you can organize peaceful protest, not violent protest. The right to peaceful protest is your fundamental right. Is it okay? This is the first thing. Second thing, right to strike is not a fundamental right. What is right to strike? Right to strike can be exercised by those people who are involved in some organization as a worker or in some of the industries as a worker. And if they are going on strike, that industry, that industrial work or their production will be impacted. Okay, that is why they are not having fundamental right to strike. They are having a right to strike as a legal right. Okay, they are having a right to strike as a legal right, but not as a fundamental right. Because in future, government employee can say that we are having a right to strike as a fundamental right, and they will also starts not performing their duties which are assigned to them, and then that particular thing can affect public at large. Yes or no? Suppose doctors are on strike, that entire healthcare system will collapse. Yes, If police personnel will on strike, entire law and order system will collapse. Are you getting my point? So strike का मतलब है अपना काम छोड़ करके प्रोटेस्ट में बैठना. Yes. So this right to strike is not a fundamental right, but a right to protest is a fundamental right, which is mentioned in article number 19, clause A, and I goes clause C. 1 clause C. Yes. प्रोटेस्ट कोई भी कर सकता है, उसको प्रोटेस्ट बोलते हैं. यहाँ स्टूडेंट ने कौन सा काम छोड़ा था अपना? दोनों में फर्क है ना. स्ट्राइक वो कर रहे हैं जो वर्कर्स हैं, है ना. दोनों में ये फर्क है सबसे बड़ा, कि काम आपने पूरा छोड़ दिया, उसके बाद आप प्रोटेस्ट करने के लिए जा रहे हो, और उसकी डिमांड भी पर्टिकुलर काम से रिलेटेड ही है कि हमारी सैलरी बढ़ा दो, हमें ऑर्गेनाइजेशन बनाना है ना. वो ट्रेड यूनियन से रिलेटेड हो गया स्ट्राइक का काम. लाइक डॉक्टर्स यूनियन. अभी 5 मिनट रुक जाओ, क्लियर हो जाएगा. ठीक है, देखते हैं इसको आगे, क्लियर हो जाएगा आपको. राइट टू स्ट्राइक. Right to strike labor is a legal right recognized with the certain restriction under Industrial Dispute Act. Okay. Supreme Court describe strike as a form of demonstration by the workers for their right. It is the form of demonstration by the workers. So in strike, only workers are involved. But in protest, everybody can be there. Difference is clear. And workers for their rights. Here you can protest like students were protesting against coaching industry. Students were protesting against irregularities, okay, higher fees and other types of exploitation which are going on in old Rajendranagar. Students were protesting because some of the students died in that flooding. Yes. अरे उनके कौन से राइट्स हैं? जो फंडामेंटल राइट्स है उसको लेकर के गए ना. बट वर्कर्स राइट्स आर डिफरेंट, लाइक हायर वेजेस, राइट टू फॉर्म यूनियन. यस. Regularization of minimum and maximum wage, regularization of working hours. It is like this. Regularization of service condition. वर्क ओवरऑल कम्युनिटी में से वर्कर एक स्पेसिफिक कम्युनिटी हो गई. इज इट ओके? And they are having specific grievances related to their service condition. Okay. समझ में आया ना कि this is the whole community, whole India, out of which one small community is workers community, and they are demanding certain rights related to their own community. That is the workers service condition, their wages, their working hours, etc. Is it okay? So when they will demonstrate, it is known as right to strike. And when they will demonstrate, the production of that company in which they are working will get impacted or not? Yes or no? When students are protesting, they are impacting only their rights, like their study hours will get impacted, but not we can say the working of a particular organization, because they are not the part of any organization. They are undermining their future if they are sitting on the protest. But when these workers are sitting on the protest, they are compromising the profit, production, and other such things of that particular industry, of that particular organization, of that particular firm for which they are working. Is it okay or not? समझ में आई ना बात? दोनों में फर्क क्या है? That is why right to strike is not a fundamental right. If right to strike is a fundamental right, then industries will not work, क्योंकि वो आए दिन बैठ जाएंगे. यहाँ प्लूटस की फैकल्टी सारी प्रोटेस्ट पे बैठ गई. यस और नो? देन हु विल टीच यू? ये फिर बोल के आओ, ये बंद हो गया यार। समझ में आई क्या बात? क्लियर है? सो राइट टू स्ट्राइक इज डिफरेंट देन राइट टू प्रोटेस्ट। प्रोटेस्ट, वो हंगर स्ट्राइक हो गया, इट इज वन फॉर्म ऑफ प्रोटेस्ट। दैट हंगर स्ट्राइक इज वन फॉर्म ऑफ प्रोटेस्ट। दैट स्ट्राइक वर्ड, ऐसे तो आप फिर बोल दो दैट सर्जिकल स्ट्राइक, सो इज इट रिलेटेड टू दिस? नो ना, वो वर्ड है सिर्फ वहां पे ऐसे, एयर स्ट्राइक, सो दैट एयर स्ट्राइक इज रिलेटेड टू दिस स्ट्राइक? नो, there is a difference between the workers strike and the other form of protest. अबे हमेशा क्यों जाएंगे? Look, one thing, one thing. They can choose right to protest. There is no issue. But they are the part of any organization. When they joined any particular organization, they signed one contract. Yes, that we will be working for this organization for 6 days in a week. And अरे रुक तो जाओ, we will work for that particular organization 6 days a week and our shift will be from 8 to 5. अब इस टाइम के बाद मैं कहीं प्रोटेस्ट पे बैठता हूं, then it will be considered as my right to protest. It is not the right to strike. Why? Because I am doing my duty, that is my legal duty, because I have signed one contract with this particular organization. So during the working hour, if I am sitting on the protest, that will be considered as the strike. Protest, one more difference is there. Strike means an organized way to protest. Like all of the workers are on the strike. Are you getting my point or not? एक single worker नहीं है. All of the workers are on the strike. लेकिन protest पे मैं अकेला बैठ जाऊं. दोनों में फर्क है. Basically, because of this strike, the working hour, the production or profitability of any organization, any industry, any firm will get impacted. That is why it is regulated by some other acts such as Industrial Dispute Act. But right to protest is a civic right. It is the basic right. That is why it is mentioned in the fundamental right. Is it okay? Pakka? Like Bhagat Singh, Sukhdev, Rajguru, they sat on the protest within the jail. That was not the strike. Why? Because they were not working at that time. So that was the protest. And that protest is considered as the basic civil right. वो सभी के पास होगा. लेकिन अपना काम छोड़ करके प्रोटेस्ट पे बैठना, वो तो स्ट्राइक हुई ना. क्योंकि आप जिस भी ऑर्गेनाइजेशन को ज्वाइन करते हो, लाइक आपकी गवर्नमेंट जॉब लगती है, तो आपका फिर वो प्रोटेस्ट पे बैठने का अधिकार गया. ठीक है? वाई? क्योंकि आपने कुछ टर्म्स एंड कंडीशन पे साइन किया है. So the normal people who are exercising their right to protest will not be exercised by those people who are employed by some of the organization or by the government. अब ठीक है? आई थिंक मैंने अपना बेस्ट बता दिया, अब इससे ज्यादा मैं बता नहीं पाऊंगा. ठीक है क्या? है ना? यस. हाँ हाँ. Basically, in strike, you will impact the working of any organization for which you are working. ये सबसे बड़ा डिफरेंस है. लाइक शाहीन बाग पे प्रोटेस्ट हुआ था. Those people who were sitting in the शाहीन बाग, और फार्मर्स प्रोटेस्ट हुआ था, वो किसी ऑर्गेनाइजेशन के लिए काम कर नहीं रहे थे. वो अपने ग्रीवांसेस रिड्रेस करने के लिए बैठे हुए थे प्रोटेस्ट पे. दैट वाज द प्रोटेस्ट. लेकिन यही किसी ऑर्गेनाइजेशन के लोग बैठने लगे, लाइक इन द Calcutta rape and murder case. Doctors were sitting on the protest, but simultaneously they were doing their duty. आपको याद हो तो? Yes, they were performing their duty. और एक होता वो स्ट्राइक पे बैठ गए, ड्यूटी नहीं कर रहे हैं. दोनों में फर्क क्लियर हुआ ना? So that was not strike, that was protest. Because they were doing their duty, performing their duty. Is it okay? So, for example, they include various forms such as go slow, sit in the work, work to the rule, absenteeism, etc. The court has observed that the right to demonstrate and therefore the right to strike is an important weapon in the armory of the workers. यहाँ स्पेसिफिक मेंशन क्या किया है हमने? वर्कर्स, है ना? ये सिर्फ वर्कर्स के लिए है, बाकी राइट टू प्रोटेस्ट सभी के लिए होता है. The right is recognized by almost all the democratic countries. The ILO considers the right to strike as a corollary to the right to organize. However, in 1947 Act does not recognize right to strike as absolute right. It is not absolute right. Why? Because if it will recognize as the absolute right, then doctors will sit on protest. Then entire health system will collapse. If workers are sitting on the protest, that industrial production will collapse. इस वजह से ये absolute right नहीं है. Section 22 prohibits the strike in the breach of contract. ठीक है? Breach of contract. Or without giving employer notice within the 6 weeks before striking, or within 14 days of giving such notice, or before the expiry of the date of strike specified in the notice, or during the pendency of the proceeding before the conciliation officer 7 days after the conclusion of such proceedings. Okay, so with respect to protest, I can sit on the protest from now onwards, because there is no obligation of mine with respect to anybody. I can sit on protest from this time onwards. But if you want to exercise your right to strike, then you should give some advance notice, some 7 days advance notice. Then that employer will hire one conciliator or send some conciliator, और वो mediation करवाएगा. यदि वो भी fail हो गया, then they will sit on the protest. It is like this. In the All India Bank employee case, the Supreme Court said that the right to form an association was guaranteed one. Right to form association is a fundamental right under Article number 19. Right to protest is also a fundamental right. But right to strike is not a fundamental right. But the methods used by the union to achieve their purpose must be adhered to the existing industrial laws. Is it okay? Then Supreme Court in B.R. Singh versus Union of India 1989 upheld that right to form association or union is a fundamental right under Article 19(1)(c. Okay? Then Madras High Court in Ramaswamy versus Registrar of Trade Union succinctly defined the history and object of the Trade Union Act, the organization of the labor to enable the collective bargaining. Collective bargaining means they will bargain with respect to their salary, working condition, social security, such as pension, yes or no, housing facility, working hours, etc. तो वो collective bargain का tool है एक strike करना. Right to strike labor is a legal right recognized within the certain, ये हमने देख लिया है. तो basically बताना यही था. What is right to strike? What is right to strike? It is a legal right. And what is right to protest? It is a fundamental right. Difference is clear or not? Clear हुआ आपका पक्का? ठीक है ना? So right to strike is a legal right, and this is the right which is exercised by the workers, or we can say the trade union for the collective bargaining. रुक जाओ. Collective bargaining. But right to protest is a fundamental right. It is the basic civil liberties. Yes, which is enshrined in part 3 of the Constitution. That is Article number 19. Is it okay? Right to protest can be exercised by anyone. But right to strike is limited to the workers. It is the strike against one particular organization for which they are working. And why they are striking? Because they are not satisfied with their salary, working condition, social security benefits, working hours, etc. Is it okay? So those Samsung workers that they are working in the factory in Tamil Nadu, they are striking against their working condition. Is it okay? हाँ, क्या बोल रहे थे? नहीं जा सकते, नहीं जा सकते. गवर्नमेंट वर्कर्स स्ट्राइक पे भी नहीं जा सकते हैं और इनफैक्ट उनका राइट टू प्रोटेस्ट भी लिमिटेड होता है. ठीक है, अभी आ रहे हैं उस पे, इसमें दिया हुआ है मैंने. इन इंडिया राइट टू स्ट्राइक इज नॉट अ फंडामेंटल राइट बट ए लीगल राइट और स्टैट्यूटरी राइट. दिस मींस इट इज गवर्न्ड बाय स्पेसिफिक लॉ rather than being guaranteed by the कॉन्स्टिट्यूशन. ये है आपका आर्टिकल नंबर 19. ऑल सिटीजन राइट टू फ्रीडम ऑफ स्पीच एक्सप्रेशन सब्जेक्टेड टू लिमिटेड. वही तो हर चीज पे आपका लिमिटेड रिस्ट्रिक्शन लगा हुआ है. प्राइमरी लेजिस्लेशन दैट एड्रेसेस द राइट टू स्ट्राइक, इंडस्ट्रियल डिस्प्यूट एक्ट, which has been subsumed under industrial relation code. In some of the lecture we will discuss that industrial relation code. This will be the big thing in the case of structural reform in India. Structural reform means like GST. GST reformed the entire taxation system, especially the indirect taxation system. This is the structural reform. That one particular thing which is repealed by the government, that is the farm laws. ये भी एक structural reform का part है. If those farm laws would have been implemented, then it will be creating a new type of system in India, like GST has created. So this particular industrial code, that is 2020, will be a next big structural reform in India. ये implement होगा तो ये एक नई चीज यहाँ पे लेकर के आएगा. We will discuss that. है ना, इसके अंदर तीन चार कोड है टोटल, है ना. एक वर्कर्स के लिए है, एक इंडस्ट्रीज के लिए, सोशल सिक्योरिटी के लिए देखेंगे. अंडर दिस लॉ, वर्कर्स इन पब्लिक यूटिलिटी सर्विस must provide a notice of strike at least 6 weeks in advance. Public utility service, like if doctors want to go on strike, then they should provide at least 6 weeks advance notice. Is it okay? Strike without proper notice or in violation of the condition set by the law can be deemed illegal, while the right to form association and union is protected under article number 19. The right to strike itself does not enjoy the same constitutional protection. For a strike considered to be legal in India, it must be comply with the, ये हमने पढ़ लिया है, ठीक है, देख लेना इसको. Government employee in India do not have legal right to strike. ठीक है, आपके क्वेश्चन का आंसर. Government employee cannot strike. Why? While joining, you will be signing a letter. आप अपने सारे राइट्स रख देते हो वहां पे कि मुझे बस ये जॉब दे दो, अब तो मुझे कुछ नहीं करना है इसके बाद. ठीक है, तो उसके बाद आपके सारे राइट्स चले जाएंगे. डू नॉट हैव लीगल राइट टू स्ट्राइक. द सुप्रीम कोर्ट ऑफ इंडिया हैज रूल्ड दैट द गवर्नमेंट एम्प्लॉय डू नॉट हैव ए फंडामेंटल लीगल मोरल, क्या बोल रहा है, मोरल राइट भी नहीं है आपका, ठीक है, मोरल और इक्विटेबल राइट टू स्ट्राइक. दिस मींस दैट private sector worker may strike under certain condition. Government employees are generally prohibited from doing so. Okay? The rationale behind this restriction to ensure the continuous and efficient functioning of the public services which are considered essential for the public welfare. Strikes by the government employee can disrupt these services, leading to the significant inconvenience and potential harm to the public. Is it okay? So this is all about right to strike and right to protest. Is there any doubt? Right to strike is not a fundamental right. It is the legal right which is mentioned in the Industrial Dispute Act, and right now it is under Industrial Relation Code 2020. Okay, but right to protest is a fundamental right because it is the basic civil liberty. and government employees do not have any such legal, constitutional or in fact moral right to strike. समझ गए? ये सुप्रीम कोर्ट ने भी बोल दिया है. ओके, लास्ट टॉपिक, आधा घंटा है हमारे पास, हो जाएगा. दिस पर्टिकुलर टॉपिक वॉज इन द न्यूज. ये मेंस में कभी भी आ सकता है. ओके, दिस पर्टिकुलर टॉपिक वॉज इन द न्यूज फॉर लास्ट 6 to 7 years, constantly in the news and constantly being heard by Delhi High Court, and right now Supreme Court started hearing on this particular matter. Okay, for last 2 years Delhi High Court was hearing that matter, and अभी कल से, okay, ये कल का ही आर्टिकल है. Okay, now Supreme Court started hearing on this particular matter, and this matter is related to marital rape. What is marital rape? Yes, forced sex. Okay, forced sex in the institution of marriage, or non-consensual sex in the institution of marriage, which is termed as marital rape. This particular rape or form of sexual abuse is not a crime in India. Why? Why it is not a crime in India? Yes, it is one form of exception, first thing, and in India marriage is considered as a, yes, sacrosanct in nature or sacred in nature. Okay, so it is considered that wife should submit to his husband, to her husband. Okay, उनको submit करना ही होगा. And this particular notion is brought or inherited from the British law. One doctrine है, doctrine of coverture, which is also saying the same thing, that after marriage woman should submit her dignity, her authority to her husband completely. Okay, so anything which is done by her husband after marriage will not be considered as the abuse. Okay, now the point is there is a contradiction in the law itself. Why? Before marriage, if anything is happening or non-consensual sex or forced sex is happening, which is considered as the sexual abuse, which is considered as the rape, but just after marrying, just after marriage, if the same thing is happening, which is not a crime in India. Yes, this is the contradiction in the law or not? Because of the marriage, you are not considering the same act as a abuse, as a crime, as a rape. But the same thing is happening before marriage, then it is a punishable offense. So it is the dichotomy in the law, it is the contradiction in the law. Yes or no? That is why this particular thing was in the news. And again, the same committee which was constituted after Delhi gang rape, that is Justice Verma Committee. कहीं पे भी women rights के बारे में बात आएगी, you should write Justice Verma Committee. Okay, so Justice Verma Committee suggested that marital rape should be criminalized. Okay, now let's have a discussion on this. A 3-judge bench headed by Chief Justice of India, D.Y. Chandrachud, has begun hearing a batch of petition challenging the constitutional validity of exception 2 under section 375 of the Indian Penal Code 1860. The challenges also extend to the exception under section 263 of the Bharatiya Nyaya Sanhita, because that IPC is subsumed by भारतीय न्याय संहिता. तो इसमें ये किसमें दिया हुआ है? सेक्शन 2 of 63. Now, these provisions grant legal immunity to Indian husband by stipulating that sexual intercourse or act by a man with his wife, provided she is not under 18 years of age, do not constitute rape. So if any husband is raping his wife, that will not be considered as a rape. This is the exception which is given under Bharatiya Nyaya Sanhita. Is it okay? Earlier, that particular thing was mentioned 14 years of age. But one of the judgment of Supreme Court changed this particular thing and increased the age, that is 18 years. लेकिन सुप्रीम कोर्ट ने उसको चेंज नहीं किया, सिर्फ एज बढ़ा दिया. Okay, because that 14 was the minor age. That is why Supreme Court increased. कोई change नहीं हुआ बहुत बड़ा. What do statistics say? While data on marital rape remains limited. Limited why? Why limited? Because their marriage will destabilize. If they are coming out and complaining, then the marriage will be gone. That is why most of the women are not reporting this particular crime. So the data on marital rape remains limited due to the stigma and legal barriers. Available statistics are deeply concerning. Legal barrier क्या है? उसको rape consider किया ही नहीं जाता. This is one of the biggest legal barrier. Okay. Next, the data from National Family Health Survey conducted between 2019 to 21 indicates that nearly one third, means every third woman, nearly one third woman, married woman, have experienced physical or sexual violence at the hands of their husband. Okay, nearly one third. 82% of Indian women can say no to sex in marriage. This is said by National Family Health Survey. So it is nothing but a type of forced sex that is going on inside the institution of marriage, which is considered as sacred. And ironically, this particular crime cannot be reported because it is not considered as the crime. Yes. Next thing, additionally, global statistics reveal that approximately 3/4 of all sexual assault. This particular thing can be used in your essay paper. Okay. That additionally, global statistics reveal that the approximately 3/4 of the all sexual assault transpire within the intimate setting, often perpetrated by the someone familiar to the survivor. Okay. So two facts are important. One, all these two facts are given by National Family Health Survey 5. One fact is this, that 82% of married women are saying that they cannot say no to the sex. Okay, they have to do that first. Second thing, one third of the total women are saying that they faced some form of physical or sexual violence by their husband. What are the genesis of exception? So marital rape exception, MRE means marital rape exception, is a colonial relic originating from doctrine of coverture in English common law, which severely curtailed married women's legal autonomy. Elucidated by Supreme Court in Joseph Shine versus Union of India 2018, this doctrine assumed that the husband and wife became single entity. ये romanticize करना ठीक लगता है, but in terms of legality is not a good idea. Okay, so it is a single entity after marriage. That is, a very being or legal existence of the woman is suspended. Are you getting this point? Doctrine of coverture बोल क्या रहा है? That legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband. ठीक है? One of the earliest instances of codification of marital rape exception can be traced back to the British jurist Matthew Hale, who wrote 1736 treaty that the husband cannot be guilty of rape committed by himself upon his lawful wife, for by their mutual matrimonial consent and contract the wife has given up herself in this kind unto her husband, which she cannot retract. Is it okay? So this marital rape exception thing is coming from English common law, and from which doctrine? Doctrine of coverture, where they are assuming that wife should submit her entire authority to her husband. Is it okay? Next thing, however, in 1991, England outlawed the marital rape exception in the landmark case of R versus R, underscoring that the common law doctrine is no longer represented the true position of a wife in the present day society. So they outlawed this particular thing, but we are still continuing with that thing. Okay, so when our prime minister is saying that we should leave that colonial mentality, okay, so we should also leave such laws as well. Okay, क्योंकि ये भी तो colonial relic है, इसको क्यों नहीं हटा रहे हैं हम? We are still continuing with this. What are the challenges before the Supreme Court? Section 375 of the IPC delineates 7 conditions under which sexual intercourse is deemed rape, such as when it occurs without the consent of the woman or when the consent is obtained through the coercion. That will be considered as the rape. Those convicted are punished with a prison term of at least 10 years, which can be extended to the life sentence along with the possible fine. However, the provision stipulates 2 exceptions. The first exception pertains to the medical procedure. As per the second exception, sexual intercourse or sexual acts by men with his वही सारा जो दिया हुआ है, which is known as marital rape exception. ये कुछ मैंने reports के भी यहाँ पे दे दिया है that which one is the safest and which one is the dangerous city for women. Okay, so New Delhi. Next, the marital rape exception therefore creates a legal fiction whereby even if all the elements of consent of the offense of rape are met, the conviction cannot take place if the parties are married and the wife is over 18 years of age. Yes or no? If they are having marriage और 18 years से ज्यादा है, वो कभी भी प्रूफ कर ही नहीं पाएंगे कि उनके साथ रेप हुआ है. Is it okay? Next thing, however, a married woman can seek recourse to the other criminal provision, such as Section 85 of Bharatiya Nyaya Sanhita, which criminalizes subjecting a woman to cruelty. So cruelty is a different thing. आपको मिल जाएगा वहां से कुछ justice मिलेगा, but the real justice lies with the criminalization of the marital rape. Yes, it is not the cruelty, it is the rape. लेकिन उनको न्याय मिलेगा सिर्फ इसको लेकर के, डोमेस्टिक वायलेंस एक्ट को लेकर के मिल जाएगा. The petitioners have argued that the exception is unconstitutional since it violates the host fundamental right, foremost among the Article 14. Yes or no? Because Article 14 is saying what? Right to equality and right to equality. In fact, Article 15 is also saying right to equality. Yes, that is, no citizen of India can be discriminated only on the grounds of race, religion, caste, sex, place of birth, residence and descent. Yes, but on the basis of marriage, you are discriminating woman. One woman which is unmarried. So if anything which is happening or anything, any criteria which I have mentioned under section 375 of IPC, that will be considered as the rape. But all the criterias are there, but that particular woman is married, then that will not be considered as the rape. So it is nothing but the violation of Article 14, Article 15, that is right to equality. One of the biggest argument against marital rape exception. The marital rape exception create 2 distinct classes of victim of non-consensual sex by denying married women the protection of laws that are extended to the unmarried woman. This, according to the petitioner, also offend the principle of substantive equality failing to address the systematic barriers to ensure that all women, regardless of their marital status, receive equal protection against the sexual violence. Next, the by specifically disadvantaging married women, the marital rape exception violates their right to not to discriminate under Article 15. यही वाला जो मैंने समझाया. Okay, that discrimination can be possible on some grounds. Okay, लेकिन मैरिज ग्राउंड पे पॉसिबल नहीं है. ठीक है. नेक्स्ट, another important facet in the purported violation of right to privacy and bodily integrity under Article 21. Supreme Court's ruling in case Puttuswamy versus Union of India, one of the most important case, है ना, not only clarified that privacy was a fundamental right, but also affirmed the concept of decisional autonomy, that is right of each individual to determine how and for what purpose their body may be used. So this is the violation of right to privacy as well. As noted by the constitutional law expert Gautam Bhatia, that the true brilliance of Puttuswamy lies, it clearly established that the right to privacy is not merely anchored in the physical spaces and institutions such as marriage, but it is fundamentally tied with the individual self-determination. Okay? But this particular exception is violating all those things. The right is therefore inseparable from the ability to make choices regarding the most integral aspect of one's body and life. In Joseph Sheen case, the top court built on the jurisprudence by observing that the familial structure cannot be regarded as the private space where the constitutional rights are violated. This is one of the most important thing. क्या बोल रहे हैं? That familial structure cannot be regarded as the private spaces where constitutional rights are violated, and that doing so to obstruct the unfolding vision of the constitution. Okay, women who experience spousal violence सबसे ज्यादा कहां पर है? कर्नाटक. Then I guess none other than one of the best state of India. ठीक है. Next, in March 2022, the Karnataka High Court in Rishikesh Sahu versus State of Karnataka and others ruled that the married man can be prosecuted for raping his wife. लेकिन क्या हुआ, बाद में इस पे स्टे लगा दिया कि ऐसा नहीं करना है. Okay, relying on 2013 report authored by Justice J.S. Verma Committee recommended the abolition of marital rape exception. Justice M. Nag Prasanna reasoned that no legal exception can be absolute as to license crime against the society. Okay. However, instead of striking it down, he made the exemption inapplicable in the cases involving the commission of heinous sexual offense by husband against their wives. ये कोई issue हो गया. The cases stemmed from 2017 complaint by a woman against her husband Rishikesh Sahu accusing him of committing multiple sexual offense. Then he was also charged with the sexual assault under POCSO. उस पे ये भी charge था for abusing their daughter as well. Okay, so an appeal was subsequently challenged in the High Court's decision, resulting in the interim stay. उस पे क्या लगा दिया Supreme Court ने? Interim stay. So that was the progressive decision made by Karnataka High Court, but that was stayed by Supreme Court. और उस पे फिर दिल्ली हाई कोर्ट का भी जजमेंट है अभी आगे, लेकिन वो भी स्प्लिट जजमेंट है तो कुछ हुआ नहीं. इन 2022 मैंने आपसे कहा ना कि ये जो पर्टिकुलर न्यूज है ये पिछले 6-7 सालों से न्यूज में बनी हुई है और इस पे अभी तक कोई क्वेश्चन आया नहीं है. सो देयर आर चांसेस दैट one question can be framed in GS paper 1 or in GS paper 2, है ना, और इनफैक्ट इन GS पेपर 4 एज वेल, एथिक्स वाले में भी आ सकता है. ठीक है, तो ये टॉपिक थोड़ा सा कॉम्प्रिहेंसिवली कवर कर दो एक बार. In May 2022, Delhi High Court rendered a split verdict. अब split में क्या है, 2 judge bench थी. One judge says that it is a crime and one said it is not a crime. तो कोई कंक्लूसिव बात वहां से भी नहीं निकल के आई. जस्टिस राजीव शाकडेव deemed the marital rape exception unconstitutional, asserting that it violates women's bodily autonomy and expression. He characterized the exception as steeped patriarchy and misogyny, adding that the classification, in my opinion, is unreasonable and manifestly arbitrary, as it implies that the forced sex outside marriage constitute real rape, whereas the same act within the marriage does not. Conversely, Justice C. Hari Shankar opined that within the marriage, sexual relations are a legitimate exception, making marital rape exception legal. Introducing into the marital relation the possibility of the husband being regarded as the wife's rapist if he has on one or more occasions sex with her without consent would, in my view, be completely antithetical to the very institution of marriage as understood in the country, both in the fact and in the law. Is it okay? उन्होंने कहा कि सोसाइटी में ऐसा हम मानते ही नहीं है. यही कहने का मतलब है. तो ना तो सोसाइटी मानती है ना लॉ मानता है, तो मैं इसको एक्सेप्शन नहीं दूंगा. देन नाउ this was the thing which was said by the center, because in almost all the cases one of the petitioner is whom? One is the petitioner is the center of state. Basically it is the government. तो सो दिल्ली हाई कोर्ट ने पूछा कि आपका क्या मत है इस पे, आप क्या बोलते हो? सेंटर ने क्या कहा? Union government's latest Supreme Court affidavit is the first time that it has been on record opposed the striking down of. So basically central government is opposing. Okay. During the proceeding before the Delhi High Court, the government had said that the issue needs wider consultation, that a review of existing criminal law was pending at that time. Drawing from the Justice Shankar's opinion, the center has argued that the marriage creates a continuing expectation of reasonable sexual excesses, which is absent in the case of a stranger or another intimate relationship. While acknowledging that a man has no fundamental right to violate his wife's consent, it has contended that classifying such act as a rape is excessively harsh and disproportionate. And it has also apprised the court that the criminalizing marital rape would affect the sanctity of the institution of marriage and potentially result in the false allegation of marital rape. Is it okay? So that was the stand made by center. Okay? Huh. Hmm. Hmm. The marriage institution will be definitely destabilized. That is why center is saying that it needs wider consultation, because the point is uh, how to prove that it is consensual or not. First thing, क्योंकि false allegation भी फिर उतने ही लग सकते हैं, है ना? ये भी तो एक एस्पेक्ट बनता है यहाँ पे. तो अभी तक इस पे डिबेट ही चल रही है कि क्या होना चाहिए. यस. तो अभी तक की डिबेट क्लियर है. मैरिटल रेप एक्सेप्शन is a legal thing in India under section 375 clause 2 of IPC. Is it okay? What is exception? That if husband is doing anything with his wife, provided that she is above 18 years of age, then it will not be considered as marital rape or any type of rape. This is the exception which is provided by the law. Okay. There are two judgments with respect to that. One judgment, that is which Sahu judgment, kya naam hai? Rishikesh Sahu judgment, where Karnataka High Court said that it is an offense and it should be criminalized. It is unconstitutional. But that thing was stayed by the Supreme Court. And Delhi High Court gave split judgment with respect to that. And this is the stand of center we have discussed. What is the stand? Center is saying that yes, okay, husband is not having, क्या लिखा हुआ है? Hmm? Yes. center is saying that acknowledging that a man has no fundamental right to violate his wife's consent, no fundamental right, but it has contended that classifying such act as a rape is excessively harsh and disproportionate. Why? Because center is an opinion, or central government is an opinion, that the classification of consensual and non-consensual is a difficult thing, especially difficult thing to prove in the court. And the allegation of false rape, okay, or forced sex will be there. That is why, while moving forward, we need wider consultation on this particular issue. ठीक है, तो ये एक ऐसी गुत्थी है जो अभी सुलझ ही नहीं रही है कि इस पे क्या लॉ बनाया जाए, कैसे इसको कंट्रोल किया जाए. इज इट ओके? है ना? बट द डेटा विच इज गिवन बाय नेशनल फैमिली हेल्थ सर्वे is threatening, is frightening. Yes or no? 82% of the total women cannot say no to sex. And one third of them are facing some form of physical and sexual violence from their spouses. It is the reality in India. Is it okay? तो दोनों ही, क्योंकि नेशनल फैमिली हेल्थ सर्वे का भी जो डेटा है वो गवर्नमेंट का डेटा है. ऐसा भी नहीं है कि आप किसी और का डेटा ला करके बोल रहे हो. ये डेटा भी गवर्नमेंट नहीं दिया है. नाउ इट इज द रिस्पॉन्सिबिलिटी ऑफ द वेलफेयर स्टेट टू सॉल्व दिस पर्टिकुलर इशू. Okay, so this is from my side. Four topics that we have discussed. One is rare disease, and one more related topic to that, that is orphan drugs. Okay, one other topic, that is neglected tropical disease. First, then second, bone ossification test and juvenile justice act. Then third, right to strike and right to protest. Clear है आपको अब right to strike? कोई डाउट नहीं है? अरे हाँ बताओ. ठीक है. If they are a government employee, then they cannot sit on strike. हमने देख लिया. If they are a private practitioner, then they can sit on the protest after giving जो भी उसमें legality है उसको follow करके बैठ सकते हैं. इस बीच में conciliation हो गया तो फिर नहीं बैठेंगे ऐसा. ठीक है. And the last topic is marital rape exception. So question can be asked on marital rape exception in the mains, not in the prelims, but other topics are related to prelims. हाँ. Yes. Okay. Thank you. हाँ हाँ हाँ.